It's not about.
It's not like you're buying something.
If I was supposed to file it in circuit court, I would have filed it in circuit court. I wouldn't have filed it to come before you.
Court is not a microwave oven or the drive-through at Wendy's. You don't get your hamburger in 5 minutes. Doesn't work that way. We're more like a crock pot. It simmers for a long time. Ma'am, did you have a trial?
Sir, what are you talking about? I went before a judge. I did not plead guilty to pulling a knife on you. It was because of his lies that I was in the county jail for 27.
Today's case features a plaintiff who appears to believe that a few online searches equal formal legal training, and that court procedure should move with the speed of a service counter. Sandra has filed a defamation claim in a court that does not have proper jurisdiction over that type of matter. Yet her primary frustration seems directed at the $70 filing cost rather than the legal viability of her complaint. That disconnect sets the tone before proceedings even begin. The situation quickly becomes an example of how misunderstandings about court structure and process can create tension with the bench. Filing in the incorrect venue signals a lack of preparation, while focusing on fees over substance suggests misplaced priorities. Judges expect litigants, even self-represented ones, to follow basic procedural rules and respect the court's function as the hearing approaches. The stage is set for friction rooted less in the underlying claim and more in approach and attitude. What follows offers a clear illustration of how early missteps and misconceptions can shape a judge's perception from the outset. Let's take a closer look at how this unfolds.
Wilson versus Wilson.
Yes, I'm here. Wilson. Wayne Wilson.
Yes, I'm here.
Sandra Wilson?
Yes, sir.
Coming from the plaintiff's space, Miss Wilson.
Yes.
What is all that racket in the background?
Oh, I'm sorry. Because I'm across the street charging my phone. My battery ran down listening to the other cases. I got to come back over there anyway because I left my paperwork. I apologize.
Wilson versus Wilson.
Yes, I'm here.
I'm here.
Okay, now.
The mediator has left. If you look at the basis of the claim,
Yeah.
that is like something else you talked about today.
Yep,
So
I know.
let's not even fool around
I
with
know.
this.
I've been down here since 11 o'clock.
Well,
Well, Miss Wilson,
I'm glad.
her case was
Thank you.
scheduled for 11:45, and she
Thank you,
did
Judge
appear
Marable.
quite early,
Thank you,
sir.
Judge
That's
Marable.
okay.
Thank you, Judge Marable.
Just wanted to note that she did appear quite early for her scheduled time to begin with.
Ma'am, Judge Marable's in charge.
Well, I'm just saying that's not a problem that you came in early, ma'am.
You shouldn't be commenting. Okay, look. Wilson versus Wilson.
Yes, sir.
Your claim is for libel, slander, defamation of character.
Yes, sir.
That is a circuit court kind of issue.
They told me it was small claims court. I looked it up on.
I don't know who is they? Who is they? Who is
I
that?
looked it up on Google to see if small claims court handles defamation, slander, and libel, and it does, sir. So if I got to take it to circuit court, I'll take it to circuit court.
Who told you that small claims handles defamation?
I Googled it. I Googled it on the
You
city of Flint.
Googled it. Oh, you Googled it. Okay.
Citing a general internet search as though it carries the same weight as established legal authority in a courtroom is profoundly misguided. It's comparable to claiming medical expertise based on a short online video, an approach no professional forum would accept. Courts rely on statutes, precedent, and verified legal sources, not informal web summaries. What stands out most in this moment is the level of certainty with which the plaintiff attempts to challenge the judge's understanding of jurisdiction, explaining the limits of a court's authority to the very official who presides over it reflects a deep misunderstanding of both procedure and hierarchy. That kind of misplaced confidence rarely helps a litigant's position. Judges are accustomed to self-represented parties, but they still expect respect for legal standards and the structure of the court system. When someone substitutes casual online information for formal law, it can undermine credibility almost instantly. Situations like this highlight how overconfidence paired with inexperience can quickly derail a case before it truly begins.
Do you have it printed out? I'm just curious as to whether or not you have a printout, because I'd like to see that.
Okay, you want me to come back in there and show you? Because
Yes,
I
would.
would not have put out the
She
paperwork for
must
small
disconnect
claims
from the
court.
meeting if she comes back in the room.
What did you say, ma'am?
Judge Marable, I would not have filed a small claims against him if it wasn't for a small claims court to decide on it. But if it's circuit court, I'll go to circuit court. It makes me no difference. I paid $70 for this small claims. So are they going to refund my $70?
Absolutely not. Do you want to know why?
Yes, sir.
Okay. For anybody within the sound of my voice, let me explain what a filing fee is and what it isn't. A filing fee is not like when you go to McDonald's and you order whatever you order. Let's say you order fries, a burger, and a Coke, and they forget to give you the fries.
She appears to view the filing fee as though it were payment for a guaranteed outcome, similar to a purchase that didn't include everything expected. From her perspective, the court seems less like a forum for resolving legal disputes and more like a customer service desk where dissatisfaction should automatically produce a remedy. That mindset overlooks the fundamental purpose of judicial proceedings. The emphasis on the $70 cost, rather than on whether the claim was properly filed or legally sound, suggests a misunderstanding of how access to court actually works. Filing fees cover administrative processing, not success on the merits, and they don't convert the court into a transactional service. When expectations are framed that way, frustration often follows. What emerges is an approach that treats the process as though the litigant holds authority over it, rather than participating within its structure. Courts operate on jurisdiction, procedure, and evidence, not consumer-style satisfaction. When someone enters with a complaint-driven mindset instead of a legal one, conflict with the system itself can become inevitable.
Basically, what you're saying is because I filed it in the wrong court, I don't get refunded my money.
No, let me finish. Let me finish, ma'am. It doesn't work where, you go back and you say, well, they didn't give me what I ordered. That's not what a filing fee is. A filing fee at a court is for the right to be able to get the case to court. You don't get to get a refund if the case doesn't go your way, or if you filed it in the wrong court, or whatever. It's for the right to be heard. It's for the right to be heard. That's what a filing fee is.
It's not about.
It's not like you're buying something.
If I was supposed to file it in circuit court, I would have filed it in circuit court. I wouldn't have filed it to come before you.
Well, but ma'am, guess who has the burden of going to the right place? You've heard me talk all day that the plaintiff has the burden of proof and persuasion. The plaintiff also has the burden of going to the right court. Now, I see libel, slander, defamation. You said that he filed some kind of false criminal charge against you?
Yes, he did, sir. Yes, he did.
Was the case dismissed?
No, it wasn't. I ended up going to the county jail for 27 days. They gave me 2 years probation. I had to pay filing fees.
So what you're telling me is you were convicted?
That's what I'm telling you. And I want to be reimbursed for the probation fees and everything, and having to find somewhere else to move, because that was my home I got kicked out of because he lied on me.
Ma'am, did you have a trial?
Sir, what are you talking about? I went before a judge. Judge Haley, whatever her name is.
Your Honor, she pled guilty.
I did not plead guilty to pulling a knife on you. I did not plead guilty to pulling a knife on him, Judge Marable. No, I didn't.
Did you enter a guilty plea?
Not on pulling a knife on him. I entered a guilty plea on a domestic violence charge, which was the lesser charge of the claim that I pulled a knife on him. I have the transcripts right here, which I brought to court to show you. It is not pleading guilty to pulling a knife on him, because I would not have done anything like that. Only way I would have done that. What
charge did you plead to, ma'am?
I told you, sir, a domestic violence for 6 words that I said to him when he said, you can't fight. And I said, you really don't want me to. And the judge,
asserting that a guilty plea amounted to nothing more than agreeing to a few words, while simultaneously acknowledging conviction for domestic violence, reflects a striking attempt to minimize the legal reality. A plea is not merely language. It is a formal admission that carries defined legal consequences. Reframing it as a semantic mix-up does not change the record the court maintains. What appears here is an effort to separate the wording of the plea from the substance of the offense, as though the convictions stem from vocabulary rather than conduct. Courts, however, evaluate actions and admissions together. They do not treat them as interchangeable or optional. That distinction is central to how prior history is considered in later proceedings. Try to recast a documented conviction as a misunderstanding of phrasing places credibility at risk. Judicial systems rely on accurate acknowledgement of past outcomes, not reinterpretation after fact. When someone attempts to downplay a recorded judgment in this way, it can further weaken their position rather than clarify it.
That was threatening, and she found me guilty of that, but not pulling a knife on him. I was originally charged with pulling a knife on him.
Let me ask you this, ma'am. Let me ask you this question. Did you plead pursuant to a plea bargain that was offered by the prosecutor?
Yes, sir.
In other words, they would dismiss the higher charge if you pled to the misdemeanor.
Yes, I know.
Well, is that what happened?
That's what happened.
Well, I don't know. Let me say this.
It was because of his lies that I was in the county jail for 27 days. I lost my home because of that lie. And I had to rent hotel rooms by the week or by the month because of that. And I want to be reimbursed for that because of that lie he told on me while he was on parole. That was a flat out lie. So
well,
I'm not a hard criminal like that.
Ma'am.
What?
Here's where we're at. I'm going to tell you where we're at. This is the kind of case that has to go to circuit.
All right. I'm on my way.
If you want to refile it in circuit to get that to relief for libel, slander, I guess you could do that. They're a court of equity, so you could do that. They have equitable power. I deal with contract sorts of claims and such.
I will.
Okay?
I will do exactly that.
So that's the, ma'am, are you talking? Let me talk.
I am.
So that's where you have to go with that type of. That's where you'd have to go with that type of claim. But I'm going to tell you, just a word to the wise. If you pled guilty to some sort of assault, was he the named victim in the domestic assault?
I didn't plead guilty to an assault, sir. I pled guilty to 6 words that I said to him during an argument.
Okay, ma'am, you said the charge you pled to was domestic.
Yeah, domestic violence because of 6 words that I said to him. That the
was
judge
he the name? Was he named as the victim in the domestic violence case?
He was.
Then I don't know where you're going to go with this.
Okay, well, I did 27 days in the county jail because of his lie. The original charge was pulling a knife on him, which was a felony. Could have got me 4 years in prison. Of course I'm going to cop to a plea. Of course I am, because I didn't pull a knife on him. I did not.
Ma'am,
so
ma'am.
27 days.
I've got a copy of the Register of Acts. It says that you got sentenced to, hang on here, let me add it up here.
I'm going to walk down to the circuit court so I can file this against him. Now, he ain't getting away with it.
You got sentenced to 93 days. They held 66 days in abeyance.
And your point is, sir, that was from the domestic violence. Violence.
It was not a no contest plea. It was a guilty plea.
For 6 words that I said to him during an argument, not for pulling the knife on him. Judge Marable, I would have been in prison.
The judge sentenced you to 93 days.
For domestic violence, for 6 words that I said to him during an argument.
Right.
Not for pulling the knife on him. Pulling the knife on him got me 27 days in the county jail. I didn't deserve that. I did not deserve that.
Well, you had 21 days to appeal your sentence.
I did not know that. I
can't help you on that. I can't help you on that.
Those things you stapled were 2 different cases.
Okay, Miss Wilson.
Yes, sir.
Can I help you on libel and slander?
Yes.
This district court doesn't have equitable powers on that kind of thing.
Okay. All right.
So I'm going to dismiss it without prejudice if you want to file in circuit, but I don't think it's going to go that far because you pled guilty. You had to put facts on the record as to why you're pleading guilty.
Okay, I'll because I said 6 words to him that the judge thought was threatening. That's why I didn't plead guilty to pulling the knife on him. That's the difference, sir.
Well, you have the ability to appeal your sentence too.
Thank you. Yeah, I know I do.
This happened this year, didn't it?
It happened in 2020. It happened in 2020.
You had a lawyer? You had a lawyer, didn't you?
Yes, and he didn't advise me that I can appeal. He did not.
Well, okay.
He did not, because had he done so, I would have done it.
Ma'am, I think,
yes.
Okay.
Yes, Judge
I dismissed it, and I've explained to you, I dismissed it, I explained to you the legal reasons for why. So all I can do is wish the two, all I can do is wish you guys, good luck in the future.
Yeah, I don't need luck, and God don't answer wishes, God answers prayers. So thank you very much, Judge Marable, and you have a blessed day.
Thank you.
This defendant seemed to approach the courtroom as though she could direct proceedings and instruct the judge, much like supervising staff in a workplace setting. That posture clashes sharply with the structure of a judicial hearing, where authority rests firmly with the bench and compliance is expected from all participants. The contrast between her approach and courtroom protocol was striking throughout the exchange. The judge demonstrated notable restraint in managing repeated interruptions and misunderstandings without escalating the situation further. Maintaining order while addressing persistent challenges from a litigant can be demanding, and the patience shown here prevented the hearing from deteriorating into disorder. It served as a clear example of how judicial composure sustains process even under strain. Share your perspective on how this case unfolded and whether you think the court handled it appropriately. Your thoughts on the outcome and the conduct displayed are always welcome. Thank you for watching. Don't forget to like, subscribe, and stay tuned for more case breakdowns.